This batch of special leave petitions under Article 136 of the Constitution arises from a final judgment and order dated 22 April 2024 of a division bench of the High Court at Calcutta. In 2016, the School Service Commission in West Bengal conducted selections for the recruitment to 4 categories of posts. Bracket 1, assistant teachers for classes 9 and 10. Bracket 2, assistant teachers for classes 11 and 12. Bracket 3, non-teaching staff of the Group C category. And bracket D, non-teaching staff of the Group D category. A notification for the state level selection test was issued on 16 February 2016. Full stop. An OMR-based written examination was held on 27 November 2016. Full stop. The final panel for candidates for class 9 and 10 was published on 12 March 2018. Full stop. The merit list and panel candidates was published on 28 August 2018. Full stop. The candidates joined as assistant teachers in or about January and February 2019. A batch of petitions was instituted before the High Court challenging the selection process of 2016. Let's stop. The selection process for assistant teachers was governed by the West Bengal School Service Commission, bracket selection for appointment to the post of teachers for classes 9 and 10 in secondary and higher secondary schools rules 2006. 16. Good stop. Likewise, there are rules governing the selection to assistant teachers for classes 11 and 12, also of 2016. The selection for the Group C and Group D non-teaching posts is governed by the West Bengal School Service Commission, bracket selection of persons for the appointment to non-teaching staff, bracket rules 2009. Page E and F को मिल जाएगा. The writ petitions before the High Court were instituted in 2021. Let's stop. From time to time, orders were passed by the High Court annulling the appointments on the ground that the process, on the ground that the appointments were made illegally. Let's stop. The appointments were assailed initially before the division bench of the High Court, and ultimately dispute traveled to this court. By its judgment dated 9 November 2013, sorry, 9 December, yeah, sorry, I said 13. 9 December 2023, 9 November 2023, this court, while dealing with a batch of petitions, directed in Achinta Kumar Mandal and others versus Lakshmi Tunga and others, footnote देखिए, SLP civil number 4078-4079 of 2023, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court. And accordingly, an order of remand was passed, was issued. Accordingly, an order of remand was passed. The order of remand has resulted in the impugned judgment of the High Court. Let's stop. The High Court has held, inter alia, that bracket 1, all appointments made in the selection processes involved were violative of Articles 14 and 16 of the Constitution, and therefore null and void. As a consequence, of the judgment of the High Court, approximately 25,000 appointments. We have the exact figure.
25,735. 25,735. All.
All right. Approximately 25,000 appointments would stand to be abrogated, 25,000 appointments would stand to be set aside. Let's stop. During the course of the hearing of the cases before the High Court, There was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged illegalities, in regard to the alleged acts of criminal wrongdoing arising from the selection process. When the matter traveled to this court, the order, the order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report to the High Court. In the meantime, this court directed that the appointments which were granted during the pendency, that the appointments which had been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Next. In the earlier order dated 9th November 2023, this court was of the view that the direction of the High Court for the termination of the services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided full stop. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which had been recovered by the CBI full stop. The court noted that the investigation by the CBI was yet to be completed full stop. The admissibility of the OMR sheet images being in question this court observed that the question of the exercise of power in relation to the discovery of electronically stored OMR sheets implicated serious allegations in regard to the manipulation of records, having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for a final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that and it would be necessary at this stage to make a brief reference to the report dated 5 February 2024, which was the last report, which was the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission, into brackets WB-SSC, SSC, had awarded a work order to a company by the name of NISA, NYSA Communication Private Limited, for scanning and evaluation of the OMR sheets pertaining to the selection tests for each of the 4 categories. The scanning of OMR sheets was undertaken by the aforesaid company at the office of the SSC. It further emerged during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Cantech, SCANTECH, Solutions Noida, which was present at the SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of the OMR were handed over by Data Scantech Solutions to NISA Communications Private Limited. In the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. The According to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. Full stop. On 15/16 September 2022, 3 hard disks were recovered from the residence of a person by the name of Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Full stop. Certificates dated 16 September 2022 under Section 65B of the Evidence Act were obtained from Pankaj Bansal. It says 16th actually. The report says 16th. 19th, all right, 19th. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI notes that a comparison of the actual, the report of the CBI contains the following observations in paragraphs 12 and 13. ये आप कॉपी कर लीजिए पेज 279 and 280 PDF में, मेन मैटर में. The above investigation by the CBI indicates that a comparison of the indicates that it has found a manipulation in respect of 952 candidates for the selection process of teachers for classes 9 and 10, semicolon, in the case of 907 candidates for classes 11 and 12, semicolon, 3481 candidates for group C and 2823 candidates for group D. Full stop. That apart, comma, the report of the High Court notes that chart is para 240, na? Yeah, 240. Can you remember? Wait. Apart from the above, report of the CBI, the impugned judgment of the High Court contains in paragraph 240 a reference to the fact that the SSC had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. Full stop. The tabulation is reproduced below for convenience of reference. ये आपको PDF page 243 को मिल जाएगा.
Paragraph 271 also.
Yeah, I got it.
271. Excess appointment.
Yeah. I have it. I've made a note. I was coming to it in a second. 259 now. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. Full stop. In the case of classes 9 and 10, in the case of the selection process, don't say that, just say this. The figures submitted by the SSC indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC. To the following extent, bracket 1, assistant teachers for classes 9 and 10, -1539, उसके नीचे 2, assistant teachers for classes 11 and 12, -199, group D posts, -669, and 4, group C posts, 416. Let's stop. On the basis of the data which was submitted before it by the SSC, the High Court has noted, the High Court has observed, into brackets paragraph 241, that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC did not discount the fact that the possibilities of the existence of further illegalities may still exist. The High Court further noted into brackets para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities The state government had also accepted that there were widespread illegalities in the selection process. Full stop. The next, on 19 May 2022, the state government the government of West Bengal, in the school education department, issued an order in exercise of the power, in exercise of the provision, in exercise of the power conferred by Section 19. Don't say in exercise. Creating 6861 supernumerary posts of teachers and non-teaching staff for absorbing waitlisted candidates and directed that appointment letters to such waitlisted candidates should be issued in terms of the recommendation of the SSC, subject to the outcome of the pending litigation before the High Court. The court has been apprised during the course of the hearing that the petition under Article 226 of the Constitution WP capital A 250-256/2022 has been instituted before the High Court to challenge the order of the government creating the supernumerary posts to accommodate the waitlisted candidates and the full stop by an interim order, comma, the government order creating the supernumerary posts has been stayed. That petition is still pending, right? Pending. It is common ground that the petition is pending before the High Court. In this backdrop, comma, the High Court, by its impugned order, has, while setting aside the appointments, directed that bracket 1, the OMR sheets available in the 3 hard disks must be uploaded on the website of the SSC. 2, persons who had been appointed from outside the panel, after the expiry of the panel, and against the submission of blank OMR sheets, must return all the remuneration and benefits received by them to the state exchequer, together with interest at 12% per annum, failing which recoveries, the outstandings would be recovered as arrears of land revenue. Semicolon, bracket 2, the CBI shall interrogate all persons who had received appointments beyond the panel, after expiry of the panel and after submitting blank OMR sheets, if necessary, by undertaking custodial interrogation, semicolon, bracket 3, CBI shall undertake a further investigation with regard to the persons involved in the state government who had approved the creation of supernumerary posts to accommodate illegal appointments, if necessary, by conducting a custodial interrogation. Semicolon, bracket 4, the SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Full stop. Other consequential directions have been issued. Next. The primary question which has been urged in the course of the hearing by the learned counsel appearing on behalf of the petitioners fall under four broad heads. Bracket 1, the data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts, is itself suspect. Since the foundation of the entire exercise is the certificate under Section 65B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. 2, in a selection process having such a large magnitude, cancellation of the entirety of the select list should be a matter of last recourse. And where a segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3, the above consideration must apply a fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made, and the direction, particularly because the direction to set aside the entirety of the appointments would have serious repercussions to employees who have served the state. And 4, while there can be no, 4, where the appointments which are tainted are capable of being identified, comma, it would be manifestly unjust for the High Court to set aside the entire selection process. Let's stop. On the other hand, comma, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to specifically identify to state that the possibility of future or further illegalities can be ruled out. Stop. In this backdrop, when a systemic fraud has vitiated the entire process, comma, the High Court was justified in setting aside the entirety of the selection process. Next. We are of the view that the submissions which have been raised on behalf of the petitioners would merit further consideration. But stop. The issue pertaining to, don't say the issue pertaining to, the certificate under Section 65B of the Evidence Act was issued, comma, as the CBI report notes, comma, by Pankaj Bansal, who was a former employee of NISA Communications Private Limited. But stop. The legitimacy of the certificate, which has been obtained from the above individual, would prima facie lie at the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. That apart, comma, from the material which has been placed on the record before the High Court by the SSC and by the CBI during the course of its investigation, it would emerge that the appointments which suffer from taint from, what did I say, from the material? Question from the course of the investigation, comma. A further issue which would merit closer analysis is as to whether the appointments which suffer from a taint can be specifically segregated. Full stop. If such an exercise is possible, comma, it would be unfair to set aside the entirety of the selection, which extends to as many as to approximately 25,000 appointments. Full stop. The court cannot also be unmindful of the impact of the setting aside of a large complement of assistant teachers who have been recruited for both class 9 and 10 and class 11-class 12 students, which would be the consequence if the impugned judgment were to be upheld as it stands. Full stop. Assuming that such a segregation is possible, this court would have to determine the modalities which would be followed for that purpose. Full stop. At this stage, the court must be guided by the fact that by its order dated 9 November 2023, this court had protected the appointments which had been granted subject to the direction to the High Court to expeditiously dispose of the writ petition. Full stop. Bearing in mind the High Court, bearing in mind the present stage of the matter, we are of the view that an expeditious and early disposal of these proceedings would be in the interest of justice, and we accordingly direct that the proceedings be listed for hearing and final disposal on 16 July 2024. Stop. In the meantime, we are inclined to continue the ad interim protection which was granted by this court in its order dated 9 November 2023, subject to the express stipulation that persons that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of the salary which may be paid between the date of this order and the final judgment of this court. Full stop. This would cover illustratively the 4 categories of individuals noted earlier, namely, bracket 1. We need not, we can just say it for the 4. In paragraph 240 of the judgment, which has been reproduced.
Your Lordship have not said anything about the state sub.
Now we just on the earlier date, the High Court has, by its impugned order, directed the CBI to investigate the creation of supernumerary posts at all rungs of the state government. Full stop. The above direction of the High Court was stayed by this court.
You didn't stay that, only said no precipitated action taken.
The above, this court, by its previous order, had directed that no precipitate action would be taken in
Clause 8 may be stayed.
in pursuance of the direction contained
Right, the investigation.
in clause 8 of the operative directions of the High Court, which is reproduced below. Just give the PDF page, please, of that.
We'll give it to the court master. 281, my lord, possibly.
Para 363.
Para 363.
Clause 8.
Mr. Rakesh Dwivedi and Mr. Jaideep Gupta, then Mr. Rakesh Dwivedi appearing on behalf of the
State
State of West Bengal
and Mr. Neeraj Kaul.
and with Mr. Neeraj Kishan Kaul, Learned Senior Counsel, state that as a matter of fact, no appointment whatsoever
Yes.
has been made in pursuance of the order of the state government dated
19th May
19
22.
May 2022,
22.
which in any event forms the subject matter of a pending writ petition before the High Court,
Court.
where the creation of the supernumerary posts has been
been
stayed. Full stop.
Except one, my lord, that was.
No, that was. In a cancer patient.
Uh,
That is an exception.
Which even this
However-
division bench has upheld.
However, it appears that there is one exception has been made in the case of of an individual
But that is not
on
a
medical grounds.
post.
Soma Das.
That is not a supernumerary post, right? All right.
It's the
That's-
supernumerary
that's
post.
all right.
Soma Das.
That's all right. Nobody is setting aside her appointment, right? Don't say that. The earlier order of this court, in regard to the above direction of the High Court, shall continue to remain in
I'm grateful.
operation.
I'm grateful.
Pending the subject to the aforesaid.
That is faster.
Subject
We are giving undertaking.
to the above, subject to the above stipulations, comma, the judgment of the High Court dated so and so shall remain stayed till.
Judgment also directs us to further investigate. Directs CBI to further investigate.
That has
we have
been
not,
stayed.
we are, the investigation in regard to the creation of supernumerary posts.
No, my lord, your lordship staying the order would stay the CBI investigation as well.
That's only in regard to the supernumerary posts.
Kindly, my lord, kindly see, my lord. Lord, 7 is, only a minute. Lord, I have not said anything, but let me say it. Lord, kindly see 7.
Look, we will not stay clause 7.
I'm
Seven,
not concerned
yes,
with 7.
All right. The direction, we however clarify that the direction contained in operative, that the following direction which has been issued by the High Court in operative direction 7.
And 9, my lord. 9 is to file report.
7 again, there's no appointees to take custodial interrogation.
No, 7 we will not stay because 7 covers 4 cases who had received appointments beyond the panel.
Yes.
After the expiry of the panel, submitting blank OMRs to.
And sorry, I'm sorry, sorry, my lord, on that, our custodial interrogation.
Lord, there has to be, my lord.
We, however, permit the CBI to continue its investigation in respect of bracket 1, persons who had received appointments beyond the panel, semicolon,
That
bracket 2.
is a dispute, I'm sorry, but
Persons
that
who were
is
appointed
I
after.
have stay of this.
that's seriously in dispute, my lord. We have
One-
challenged.
We should go those who have been identified.
My lord, let 16th of July, my lord, the judgment as such will be stayed. Sorry.
No, investigation.
The judgment.
All right, Aisa Likho, in modification of the previous order, we direct that the investigation, which has been ordered by the High Court, pursuant to clauses 7 and 8 of its operative directions, in paragraph 363, by the CBI shall continue, but no coercive steps
Very,
shall be
no,
taken.
but let's not 8.
Rest of the order is stayed.
Not 8, my lords.
Why?
My lords, 8 involves the cabinet.
That is supernumerary, my lord.
8 involves supernumerary, the cabinet force. And that's why your lordship
Nine.
stated. Your lordship
and
says
nine.
7 and 9, not 8, my lords. That is people who
7.
prepared the cabinet.
Only whether they identified illegalities, not they should
Second.
go.
7
Shall
and
we-
9.
We have said 7. 9 is an adjunct of 7.
Yes.
8 in regard to the creation of supernumerary posts we have stayed right now. So that's-
My lords, the lordship may just clarify that. That's all that we are saying.
Just 1 second, just 1 second. The supernumerary posts, we have recorded the statement of the government that not a single appointment has been made to a supernumerary post. And that's the subject matter of a pending petition before the Calcutta
Right.
High Court where that has been stayed.
High Court was asking.
And insofar as the other categories are concerned, in clause 7 of the order,
Yes.
we are permitting the CBI investigation to
Right.
continue,
Right.
subject to the stipulation regarding clause.
Slips have granted.
Chalo, take that.
Grateful, man.